Okay. Can you see that okay?
Yes.
Yes.
Okay, perfect. Thank you. Thank you. Thank you all so much. Okay, so thank you all so much for coming today. My name is Maya Ziv-El. I am a fair housing attorney at Prairie State Legal Services. Prairie State is a legal aid and nonprofit law firm. We have offices all over the northern part of Illinois. I am based out of our Waukegan office, our Lake County office, which covers all of Lake County. I'll have some contact information at the end of the presentation today. Just a quick disclaimer before we start. I'm going to talk about the law in general today. I can't give you specific legal advice about a specific legal situation because I'm not your attorney. But if you do have specific questions to you about something going on, I'll give you information for how you can contact our office at the end of the presentation. It's kind of fitting that we're doing this as it says on this first slide. It's Fair Housing Month, and so I'm excited to be doing this for you in April because it was April of 1968 that the Federal Fair Housing Act became law. So it was just a few days ago, April 11th, I think it was April 11th, 1968 was when it was signed into law. And so it's our 56th anniversary of the federal law. And so every April is called National Fair Housing Month, where we commemorate the passage of the Federal Fair Housing Act. So first, I'm going to talk to you about the state and federal protections, and then I'll give you some examples of what discrimination can look like, and then I'll kind of finish out with some rights of people with disabilities, the additional rights in fair housing for people with disabilities. And I'm sorry, I'm going to talk a little bit fast because I want to make sure we get through as much as possible. But like I said, if you want to put questions in the chat, you're welcome to. Otherwise, also at the end of the presentation, you can also ask me questions. You can unmute yourself as well and do it that way. All right, so as I mentioned, the federal law, it's the Federal Fair Housing Act. This is the law that protects people all over the United States against discrimination in housing. And under the federal law, housing providers, landlords, I usually say landlords because in my work, I mostly deal with clients who are renters. And so the type of discrimination I see is mostly with landlords and renters, but there are, I'll show you in a little bit, other housing providers that also have to follow fair housing laws, but I'm just going to use the word landlord because it's what we see most often. So landlords and other housing providers cannot discriminate in housing under the federal law based on what we call protected classes. These are the 7 protected groups that are protected against discrimination at the federal level. So the first one is disability, and disability includes both physical and mental disabilities, race, sex or gender, color, national origin, religion, and family status. And family status protects people with children. Well, actually, you know what? I won't give it away. I'll tell you in a second. I have a slide for each one of these to explain this in a little more detail. So disability, as I mentioned, protects people both who have physical and mental disabilities from discrimination. And as I mentioned, I'm going to tell you in a little bit towards the end of the presentation what these additional rights of people with disabilities are in fair housing. There are also protections against discrimination based on someone's race and color, someone's sex or gender. And actually in 2021, HUD, which is the Department of Housing, the Federal Department of Housing and Urban Development, who is the federal agency that enforces the fair housing laws, they came out with a memo that even though sexual orientation is not a protected class at the federal level, meaning there's nothing in the law, in the federal law, that says that landlords can't discriminate based on someone's sexual orientation. But HUD came out with this memo in 2021 that said that they're going to consider if someone comes to them with a complaint of a landlord discriminating based on their sexual orientation, they will take that case as a type of discrimination based on sex. So sex discrimination also includes protections against sexual harassment. I know that it doesn't sound obvious that sexual harassment is a type of discrimination, but it is under the federal law. So sexual harassment can be either quid pro quo or a hostile environment. Quid pro quo example, quid pro quo means, this giving something for something else. So an example would be a landlord requiring a sexual favor in exchange for a housing benefit, or something like that, or a hostile environment, inappropriate touching or harassing language or comments. It has to be severe or pervasive under the law, meaning it has to be to rise to the level of a violation of the Fair Housing Act. The sexual harassment has to be severe, meaning like pretty egregious, or pervasive. Pervasive means ongoing. Like if maybe a landlord, every time they see a tenant walk by, makes a comment about her clothing. Well, maybe if the landlord made a comment just one time in passing about, oh, you're looking good today in that outfit, that might not rise to that level. But if it's something constant, every time the landlord sees that tenant, they make a comment about her appearance, that could possibly rise to the level of sexual harassment, discrimination under as a sexual harassment. So those are, and it applies to employees or maintenance receptionists, etc. Actually, that really goes for anything in fair housing, is that if there's a company, a management company, or any other housing provider, all the employees of that company are also have to follow the fair housing laws. So if you rent and you work with a management company, anyone that works for that management company, from the owner of that company to the property manager to a maintenance worker, any of those employees, none of them can discriminate based on for any reason, based on someone's protected status, protected class. Okay, so the federal law also protects against discrimination based on someone's religion, someone's national origin, which means, like it sounds, where the country that someone is from or where their family is from, and family status. Family status or familial status protects people with families who have children who are under the age of 18 in their household against discrimination, or it can include also women who are pregnant or families who are in the process of seeking custody of children. Okay, so here's a hypothetical about sexual harassment in housing. I have a couple of these in here just to get you thinking a little bit. I'm not gonna make you answer it out loud, just something to think about. It's not a quiz, you're not graded or anything, but just an example to think about sexual harassment in housing. So Charlie keeps telling his neighbor Avery that she looks sexy, and he makes comments about her body. Avery tells Charlie to stop, but Charlie continues. After a few weeks, Avery complains to the property manager. The property manager tells Avery that Charlie pays a higher rent and is a long-term tenant. She also refers to his actions as harmless. Avery keeps complaining. The property manager issues her a lease non-renewal notice, explaining that she will feel safer and happier somewhere else. So is that a fair housing violation? So the property manager gave Avery a notice that her lease is not an eviction notice, just that her lease is not being renewed because of her complaints about the comments that Charlie is making to her. Is that a fair housing violation? So here are your options. Is it, so either no, because verbal comments of a sexual nature are not enough. Yes, this is an example of sexual harassment. No, because Charlie is not a housing provider. Yes, but only because it was male on female harassment, or no, because a landlord can choose not to renew a lease for any reason. So I'll let you think about that for a second. And let you read it for one more second. Okay. I will tell you what the correct answer is, and then I will tell you why the other answers are wrong. So yeah, the answer is B. It is an example of sexual harassment. And the reason, so first of all, verbal comments are enough. Like I said originally in my slide, sexual harassment doesn't have to be physical. It can be verbal comments as well. C is incorrect because just because Charlie is not a landlord, you'll recall in the example, Avery told her landlord that Charlie was harassing her, right? Avery told the landlord how she was being treated, and the landlord didn't do anything to protect her or to reprimand Charlie. In fact, the landlord took action against Avery instead. So in those situations where a landlord doesn't take action when a complaint comes to them because of some kind of harassment by a tenant to another tenant based on their protected class, like in here, one tenant sexually harassing another tenant, now the landlord is actually liable, meaning the landlord could actually be on the hook for discrimination for not protecting that tenant, for not taking action to protect that tenant after they received a complaint. D is incorrect because it doesn't matter if it's male on female harassment or female on male harassment. The gender doesn't matter. And E is incorrect because although it's true that landlords can choose most of the time, 99% of the time, that comment is true, right? Landlords are allowed to choose not to renew a lease for any reason, unless it's for a discriminatory reason. So a landlord can choose not to renew a lease to a tenant for any reason, unless it's for something that violates the Fair Housing Act. So if they don't want to renew the lease because of the tenant complaining about sexual harassment, or because of something else, or maybe a tenant filed a fair housing complaint against the landlord, or I'm going to talk to you in a few minutes about reasonable accommodations by people with disabilities. Maybe a person with a disability asked for a reasonable accommodation and the landlord didn't want to have to deal with that tenant anymore. And those were the reasons that they didn't renew the lease. That could be a discriminatory reason. So in that case, so that's why the answer E is incorrect. All right, so that's the federal Fair Housing Act. Now let's talk about the Illinois law. The Illinois equivalent, or the Illinois law that protects against discrimination in housing, is called the Illinois Human Rights Act. And the Illinois Human Rights Act actually has a section that protects against discrimination in housing, and another part of the law that protects against discrimination in the employment setting. I do not have any background in employment law, so we're not going to talk about the employment side, only the housing side. But I just wanted to make you aware of that the act also has protections in employment law. So under the state Illinois Human Rights Act, we have additional protections against discrimination. So in Illinois, landlords also cannot discriminate based on someone's age, marital status, military status, order of protection status, pregnancy, sexual orientation, arrest record, source of income, and immigration status. And I think I have a slide on each of those. Yeah. All right. So I'll explain to you briefly what each of those means. So age discrimination, I usually if I'm doing this presentation in person, I usually have people guess what is the protection, what age does this protect people from? So landlords cannot treat people differently who are what age and over. People usually guess either 18 or sometimes they say like 65. The answer is actually 40. So if a landlord chooses not to rent to anybody because of their age being 40 or anything over 40, that's a type of age discrimination. A landlord not wanting to rent to somebody because, say, they're in their 20s, that's under 40, so that's not protection. That's not age discrimination. That's not illegal age discrimination under the Illinois Human Rights Act. Marital status. So if a landlord treats people differently, renters differently, who are either married or single. We had a landlord, this was not in Lake County, this was somewhere else in Illinois a few years ago, a big management company that had this policy that men and women who were wanted to sign a lease together had to be married. So they didn't, if there was a couple or even friends, male and female friend or a couple that wanted to sign a lease together and they weren't married, they had this policy that they wouldn't rent to them. They had to be married. That's discrimination. That's discrimination based on marital status. Protection against discrimination based on military status, which includes if someone was unfavorably discharged from the military, if somebody is in the military, active military, a veteran, landlords cannot treat them differently based on their military status. Order of protection status in Illinois, we also have a protection. This protects the person who has the order of protection, so the victim who has the protected party, who has an order of protection. Also, sometimes it's known as like a restraining order against somebody related to domestic violence. It can also include somebody that has a stalking no contact order or a civil no contact order, which are kind of similar in that same realm of no contact orders, where someone has to stay away from them because of some kind of violence issue. And it also protects people who have out-of-state orders of protection. I think I have a hypothetical on this, but the takeaway with this one is sometimes a landlord might have a stereotype that if someone has an order of protection, that there might be more, they don't want to rent to someone with an order of protection because they assume, oh, well, you have an order of protection. That means there's going to be a domestic violence situation here. There might be more police activity here. I don't want to rent to you because of that. So that would be a type of discrimination in Illinois. All right. Oh, here's I did have I knew I had this hypothetical. I couldn't remember if it was right after that slide. So a landlord has a zero tolerance for crime provision in his standard lease. So that means the landlord says, if you commit a crime while you're at my property, you will be, if that the lease says you're in violation of the lease, you're going to be evicted. So there's a husband and a wife and they argue. And so one day the husband is arrested for domestic violence and the wife gets an order of protection. And so the landlord files an eviction against them. Remember, the landlord has something in the lease that says that if there's a crime committed at the property, then you're in violation of the lease. So the landlord will evict, has the right to evict. So the landlord files an eviction against both of them. So is that a fair housing violation? So your options are A, yes, because the landlord is trying to evict someone with an order of protection, or OP for short. B, no, because the landlord has a safety interest. C, no, because of the crime-free lease provision. D, not sure, because the landlord may not have known about the order of protection. I think there are two good answers here. This is a little bit of a tricky one. So I'll tell you that the wrong answers are B and C. Because again, this could be a type of discrimination based on order of protection status. So yes, so I think the best answer is probably D. If the landlord didn't know that the wife had an order of protection and then attempted to evict her, if he didn't know that she had an order of protection, then that might not necessarily be that wouldn't be discrimination, because he's not treating her differently because she has the OP, because he didn't know about it. But then once he finds out about it, if she tells him, or immediately when the landlord finds out that there is an order of protection, he should dismiss the case against the wife only. He cannot, that would at that point be discrimination based on someone's order of protection status. But A is also a good answer as well. All right, and the last few protections, we have protection based on pregnancy. So landlords can't discriminate against women who are pregnant. Sexual orientation, which includes gender identity. And now I'll talk about the 3 newest protections in Illinois, starting with the first of the newest, so the oldest of the 3 newest ones. In 2020, the Illinois Human Rights Act was amended to add arrest record as a protected class. So arrest record, the law defines arrest record as an arrest that didn't lead to a conviction, a juvenile record, or a record that was expunged, sealed, or impounded. So you'll notice that it doesn't say that a landlord can't consider criminal records. Landlords can and have the right to run background checks, to check criminal records, and in general, that's not a fair housing violation. This protection only applies to arrests that didn't lead to convictions, or juvenile records, or records that were expunged, sealed, or impounded. So if someone has a case that they were arrested and either the case was dismissed, or they were found not guilty, or it was a case from when they were under 18, or it was a sealed case or something like that, and a landlord runs a background check and finds one of those things and says, you're not eligible, like you have this is a criminal history here, they can't consider those things. A landlord cannot treat someone differently based on an arrest that didn't lead to a conviction, or any of the other things on that slide. All right, the second newest protection which is source of income. Source of income became effective in Illinois under the Human Rights Act just over a year ago. It only became part of the law January 1st of 2023. And here I have in bold on this slide what source of income means. And this definition comes directly from the statute, directly from the Human Rights Act. It means the lawful manner by which an individual supports himself or herself and his or her dependents. So when you think about the way that you might support yourself, and if you live with children, or if you live with family, that you might support other people, any lawful means by which you support yourself or others, or dependents, is a type of source of income. So here I put on here examples of what source of income could be. So what are some examples of ways that people support themselves? Of course, the most obvious one, which I didn't put on here because it's the most obvious one, is if someone has a job, right? If someone has a job, the money that they get from that job is a source of income. But here are other examples of other ways that someone might support themselves and their families. Housing choice voucher. So the Lake County Housing Authority, and there might be some people on the call today that have housing choice voucher, or some people otherwise known as some people call them Section 8 vouchers. That is a way that some people support themselves, right? They have a voucher, and that voucher allows them to rent from a landlord where the housing authority, the voucher covers a specific dollar amount, and the housing, depending on the person's income, they pay a portion of the rent. They pay approximately 30% of their income to the rent, and then the housing authority covers the rest of the rent. So that's the way that some people might support themselves. And here's some other examples: veterans benefits, supplemental security income, retirement income, all these other examples on here. are all other ways that people might support themselves. So a landlord that has a policy, and I'm going to get into it in a little more detail in just a second to give you some examples of what source of income discrimination can look like. But a landlord that refuses to accept another source of income as proof of income is discriminating is discriminating under this law. So if a landlord has a policy that in order to be eligible to rent, you have to show that you are employed, that you have a job, that you're getting money from a job. That could be source of income discrimination, because if I can afford that place that I'm trying to rent and I don't have a job, but maybe I can afford it because I have something else on this list, like a voucher or something else on this list to help me support myself and pay the rent, a landlord just restricting it to saying someone can only rent there because they have to have if they have a job, that's source of income discrimination. I think that at least in my work as a fair housing attorney at Prairie State, what I'm seeing the most of is discrimination against, since this became law in 2023, is discrimination against people with housing choice vouchers. So it used to be that landlords in Illinois, this not in Cook County. Cook County has actually, and Chicago have actually had protections against source of income discrimination for a very long time. But everywhere else in Illinois, including Lake County, landlords could decide not to rent to someone with a voucher because they have a voucher. We don't accept vouchers. Well, now a landlord refusing to rent to somebody because they have a voucher, is discriminating. That's a type of source of income discrimination. And a lot of people with vouchers don't know that. A lot of landlords don't know that. So now you do, if you didn't know that before. But yeah, so that's a really big deal. And it has the potential, in my opinion, to really make a big impact on a lot of people, and hopefully give people a lot more opportunity to find housing in Lake County that they weren't able to before, because landlords have to accept their voucher. And then the last protection in Illinois, the most recent one, which just became law just a few months ago, January 1st, 2024, immigration status. That's our newest protected class in Illinois. And there is this definition in bold. It protects the definition of immigration status under the law is a person's actual or perceived citizenship or immigration status. So anyone, a real estate broker, an owner, a landlord, a salesman, they cannot discriminate based on someone's immigration status. There's an exception, though, if the use of the immigration status is in compliance with state or federal law. So there's a lot of housing programs which are funded by the government, such as if you live in public housing, or if you are in some kind of subsidized housing where the funding, which is subsidized by HUD or by the federal government, where you're paying maybe a portion of the rent based on your income, or you have a voucher. And in a lot of programs like that, you have to show proof of your status, of your citizenship status, and that is legal. So if it's allowed by law, then it's not immigration status discrimination. Okay, so now I'm going to give you kind of the three broad categories of types of discrimination, to get you thinking just a little bit more about how discrimination plays out in the real world. So I divided it into three categories. So the first category is overt or intentional discrimination. So this is really otherwise known as obvious discrimination. This is discrimination that if you saw it or you heard it, you would be able to pretty much identify, or it would be pretty obvious that this was discrimination. You would be able to identify right away that there was some kind of fair housing violation. So here are some examples. A discriminatory statement. Someone straight out saying, we don't rent to families with children. That's a discriminatory statement. If you heard that, you would know that is that's a type of discrimination, right? Sexual harassment, which we talked about, in hostile environment. Retaliation, taking action against someone for asserting their fair housing right, like that example with Avery and Charlie early on, where the landlord decided to retaliate, to not renew the person's lease, threatening someone or steering someone because of their protected class. So these are all examples of obvious discrimination. Category number 2, covert or different treatment. So here are examples, still intentional discrimination, but sometimes it's a little harder to identify. Different, just like it sounds, different treatment. It's a landlord that is treating two people differently based on someone being in one of these protected classes that we spoke about at the beginning of the presentation. So lying about the availability of housing, telling somebody, a landlord, that maybe the landlord tells an African-American applicant that the unit is no longer available, and then an hour later a white applicant comes and the unit all of a sudden is available again, right? So that landlord just lied about the availability of the housing to the African-American applicant. So that's a type of different treatment. Or flat out refusing to rent to someone, like the example I just gave before, having a policy. We don't rent to, the example I gave about the marital status earlier, that management company refusing to rent to couples that were not married. That's a type of discrimination, treating people differently, refusing to rent only to certain groups of people, or having different terms and conditions to a lease. Sometimes the discrimination, I've been giving a lot of examples of discrimination that happens before someone is living at the property, where landlords don't actually agree to rent to someone because they're in one of these protected groups. Sometimes the discrimination happens when the tenant is already in the property. So, for example, like with different terms and conditions, an example could be, say there's a unit and it's the exact same unit, but a landlord has charges, maybe the landlord charges a higher security deposit to a large family that's living in that unit. And then if there was a couple with no children, they charge a much lower security deposit. And the landlord says, well, I need to charge the family a higher security deposit because they have a lot of kids. They might cause more damage. I need to protect myself. Well, that's still, you got to treat everybody equally, right? Fair housing is all about treating everybody the same. So that's a different term or condition to a lease. That would be a type of discrimination. And the last one, which is kind of interesting, is the last category, hybrid or other. Sometimes all the examples that I've been giving you are have been intentional discrimination. There's been there's been intent on the part of the housing provider to discriminate, to treat somebody differently. There are some circumstances where intent is not required. And so examples of that: refusing to grant reasonable accommodations and modifications, which I'll talk about in just like 5 minutes or so. Disparate impact is a really big one. So which means there's a neutral policy, but it has a discriminatory impact on a certain group. So on a certain protected class. So an example of that, I can't remember if I have the source of income example in here. But so an example of that would be like a 3 times the rent policy. I don't know, Liz, if you can mute. I think there's somebody that's not muted. I don't know if you have the power to mute them, but I'm getting a little bit of feedback. All right, so disparate impact is a neutral policy that has a discriminatory, like I said, a discriminatory effect. Something common that I'm seeing a lot, especially, I mean, I think it's all over Illinois, but since I practice in Lake County, I see it a lot in Lake County. Clients telling me that there's landlords that have these 3 times the rent policies. A 3 times the rent policy, meaning that a person has to show that they make 3 times the monthly rent to qualify to live there. Well, so like if the rent was $1,000 a month, 3 times the rent policy would mean that the landlord is requiring that you show that you are earning at least $3,000 a month. Well, even though on its face, that doesn't sound like it's discrimination. A person with a voucher would pretty much never qualifies to rent under those 3 times the rent policies. So that's an example of a disparate impact. It has a discriminatory effect on someone based on the fact that they have their source of income, that they have a voucher. I'm going to breeze through this, but kind of going into that in a little more depth with source of income, just because we do see so much of it, especially since 2023, when this became law. We see a lot of people with vouchers who can only find housing in certain parts of the county or in certain neighborhoods of a city, not necessarily where they want to live. And sometimes, unfortunately, if someone can't find a property or a landlord that will accept their voucher, they will end up, unfortunately, losing that voucher. And so here's some examples looking at what source of income discrimination can look like. And using those 3 categories that I just mentioned. So remember, the first type of discrimination, the first category I mentioned was obvious discrimination. So here's some examples on this slide of obvious discrimination based on source of income. So if you saw a Craigslist ad that just said, no Section 8, or someone said on the phone, oh, this building isn't approved for Section 8, or you have to have a job to rent here. These are all examples of obvious discrimination based on someone's source of income. And here's some examples of different treatment. I mentioned that landlords can run background checks, right? Landlords, that's perfectly legal. Landlords are allowed to run background checks. But if a landlord is only performing background checks on certain people and doesn't have a policy that they're doing background checks on everyone, like maybe they're only running background checks on applicants that have vouchers, but if someone's applying and doesn't have a voucher, they're not running a background check. That's a difference in treatment. Or same with credit score. Landlords are allowed to run credit score, or allowed to check credit scores. That's also perfectly legal. But again, if they're only doing it for certain people based on their source of income and not others, that could be a type of discrimination. And then here's that third example that I just mentioned before on a slide with the discriminatory impact. This is a policy, this 3 times the rent thing that I see so much in Lake County. You have to make 3 times the rent to live here. Pretty much makes it impossible for someone with a voucher to ever qualify to live there. An alternative policy that would still, I think, achieve what the landlord is trying to do, because right, like a landlord wants to be able to, I understand landlords want to be able to landlords also want to be able to rent to people who they know will be able to afford the rent, right? So they do have the right in some sense to check that someone has the ability to pay their rent. But in terms of a voucher, that rent, the housing authority's portion of the rent is guaranteed. So I think a better policy, a less discriminatory policy would be if a landlord has a policy that says, prove to me that you have to show me that to apply here, you have to show me that you make 3 times your portion of the rent. Then that would not be discriminatory. So if I have a voucher, say, and in that example I gave before, say the rent was $1,000 a month, and my portion of the rent is only $300 a month, and the housing authority pays the other $700. I'm sorry. This example, my income is $300. My portion is $90 a month, and the housing authority is paying the other $910 a month. Then I would need to show that I make 3 times my portion, so $270. That's a lot of math. That would be a policy, a less discriminatory policy, because under a policy like that, someone with a voucher would always qualify. Now, I just want to say as a caveat that the source of income has not really been litigated at the state level yet. It's been litigated. There have been cases in other states that have source of income protection. Like here's an example from a case in Connecticut and another one in New York. But because we don't have any case law at the state level in Illinois, a lot of the things I'm saying are my interpretation of the law, but it will also take some actual cases and decisions by judges to know how some of this is interpreted. In January of this year, in January of 2024, IDHR, the Illinois Department of Human Rights, which is the state agency that enforces the fair housing laws in Illinois at the state level, they released some guidance, it's really helpful. It's a frequently asked questions section, and you can find it on their website. And I think there's a link to it right from the homepage to their website. If you Google Illinois Department of Human Rights, there's a frequently asked questions section, and they give a lot of really good guidance on how they interpret the source of income and what they think could be discrimination and under the new law. So that's a really good place to look for some reference. Here are some examples. Like I mentioned before, Illinois, it's a new protection at the state level, but Chicago and Cook County have had local source of income ordinances for many years. So here are some defenses that landlords have raised in cases in Chicago, in the Chicago area, as to why, when they were sued for refusing to rent to somebody with a voucher. So an example, so in one situation, a landlord said, that was being sued for refusing to rent to a voucher holder, said, well, a voucher isn't income. That's not a type, that shouldn't be protected because it's not a source of income. Or one said they don't want to deal with it's not that they don't want to rent to voucher holders, is that they didn't want to deal with the whole voucher process, working with the housing authority. They didn't want, there's a contract that a landlord is required to enter into with the housing authority, that's required, a separate contract, which explains like how the payments are going to be made or where they're going to be made and the amounts and things like that. So sometimes the landlord says, well, it's not that we didn't want to rent to a voucher holder. We just didn't want to have to enter into this separate contract, or it's not that we didn't want to rent to voucher holders, but we're not approved to rent to Section 8. We're not approved to rent to Section 8 voucher holders. So those were all defenses that, according to these cases, didn't hold up. In these cases, on the right there, the judges said, these were not valid defenses. It was still source of income discrimination. So like I said before, fair housing, I've been mostly talking about landlords, but other housing providers, which pretty much means anyone involved in the housing industry, have to follow these laws against discrimination. So it includes not just landlords, but also sellers of real estate, so realtors, banks and lending institutions, insurance companies that provide home insurance, public housing authorities, and any agent employee. I mentioned that before too. So anyone that works for one of these companies also has to follow the fair housing laws. So I'm going to quickly finish up with the rights of people with disabilities. I know it's already 12:45, and I want to make sure to give a couple minutes in case there's any questions. So as I mentioned, people with disabilities have additional rights. Everything I've been talking about so far for the last 45 minutes has been about housing providers having to treat everybody the same, regardless of their race. People have to be treated the same regardless of their marital status, regardless of their religion, they're having kids. But people with disabilities, here I'm turning that on its head a little bit, because people with disabilities have additional rights that the other protected classes don't have, and those are the rights to request reasonable accommodations and reasonable modifications in their housing. And here's the legal definition. A disability means a physical or mental impairment, so it can be something physical or mental, which substantially limits a major life activity. So what that means, what's a major life activity? Basically anything that you probably do on a daily basis, that's a basic function of life. Caring for yourself, here's some examples. Seeing, hearing, eating, walking, standing. These are basic things that you might do every day. So a disability might prevent somebody from being able to do one of these major life activities, or make it more challenging, or that they can only do this major life activity under specific circumstances. So here's a little pop quiz. I think this is my last one. Which of these would qualify as a disability? Anxiety, spinal stenosis, a current user of illegal controlled substance, or someone recovering from substance abuse? And the answer is almost all of them. So anxiety, yes, that's a disability, because remember I said mental disability counts as a type of disability. Spinal stenosis, that's a physical disability, so that counts. D, that's correct. Someone recovering from substance abuse, that would be considered a disability. However, there is an exception in the law for C is not correct. So if someone is currently using, has like an addiction to an illegal controlled substance, that's an exception. So they are not considered a person with a disability. So what are these rights that people with disabilities have? I mentioned one of them, the right to request a reasonable accommodation. People with disabilities have the right to request changes or exceptions to rules or policies to allow them to more fully enjoy their home, their housing. And here are a couple of pictures to illustrate this on this slide. So there's a lady with a cute little dog there, and that's to give the example of emotional support animals and service animals. So I see this a lot. Landlords that have policies, a lot of landlords have no pet policies. They don't allow pets for their renters. Well, if somebody has an emotional support animal, they have the right to ask for a reasonable accommodation, that the landlord give them an exception to that no pets policy for their animal, because it's not a pet. It's actually an animal that's helping them alleviate with the symptoms of their disability. That middle example, adding a caregiver, maybe adding a live-in aid to a lease as a reasonable accommodation, or maybe asking to transfer to a lower floor unit in a building without an elevator because somebody has difficulty walking on the stairs. Reserved parking spaces is a really big one too. I've seen that a lot too. If someone is living in an apartment building that doesn't have reserved spots, maybe they need a parking spot as close as possible to the entrance to the building, because it is hard, because of their disability, it makes it hard for them to walk long distances. It makes it so it's because of some kind of disability, it is helpful for them to have the spot closest to the door. So asking as an accommodation, even though the landlord doesn't generally have reserved spots, making a reserved spot especially for that tenant, guaranteeing that they have that spot close to the entrance to the building. And then finally, we have reasonable modifications. So people with disabilities also have the right to ask for physical changes to be made to the property, like making a bathroom accessible. There you can see like a walk-in shower, or adding a floating vanity there, or like the bars on the side of the toilet, widening a doorway for someone in a wheelchair to be able to fit through the doorway, or a ramp, or a fire alarm that lights up for someone maybe that can't hear the fire alarm. So those are all examples of physical changes to the property. The key here is that while landlords have to allow the person to make the change to the property, in most cases, unfortunately, the landlord does not have to pay for it. So the only exception to that is if someone is living in housing that receives federal funding. So in public housing, or like project-based subsidized housing, where they're paying a portion of their income is calculated based on their portion of the rent is calculated based on the income. That's the subsidized housing, because that landlord receives federal funds. In those cases, the landlord would have to pay for the physical change. But in most cases, if it's private housing, or somebody that is using a voucher renting from a private landlord with a voucher, in those cases, even though the landlord has to allow them to make the change, they don't have to pay for it, which obviously is challenging to a lot of people, because a lot of times modifications can be very expensive. I'm going to skip this just in the interest of time. And the only thing I want to say here on this slide is that Landlords, so obviously a housing provider has to know that a tenant has a disability. It has to be necessary. Whatever they're asking for has to be somehow, there has to be a nexus between what they're asking for and the effects of their disability. So the accommodation or the modification has to somehow be related, of course, to their disability. They have to actually request it, right? A landlord can't read someone's mind. So most of the time they have to be able to actually ask it unless it's something obvious, like somebody in a wheelchair needing a ramp because there's a step to get to the front door. That's pretty obvious. In that case, they shouldn't have to ask for that. A landlord should just know that that modification is needed. It has to be reasonable, which is, like, in the eyes of the law, reasonable is very subjective. And there can't be a direct threat. So this is the only really one of the only ways that a landlord has the right to refuse to grant an accommodation or modification is if there's some kind of health or safety threat, and there's no other way to minimize that health or safety threat. Okay, I just said that. Finally, think about the reasonable accommodation and modification process is really an interactive process. This is what HUD has said in guidance, and a lot of judges have said it in cases as well. Think of these as not just a tenant coming asking for a request and then the landlord either saying yes or no, and that's the end of the conversation. It needs to be really an ongoing dialogue between the two parties, even if the original request is not reasonable, or maybe the landlord cannot grant the original request. It's impossible to grant what the person is asking for. Or maybe the person didn't provide proper documentation to show that they're actually disabled or explain why they need it. In situations like that, a landlord can't just say, oh, you didn't get me what I asked for, or no, I can't accommodate you, sorry, goodbye, close the door. They're required under the law to enter into a discussion with the tenant to see if they can somehow accommodate them. Finally, for someone who has a fair housing complaint, what are the ways that they can, who do they complain to? Like, how do people file fair housing complaints? There's two different forms, either administratively or in court. And I referenced both HUD and IDHR. HUD is at the federal level, IDHR at the state level, are both federal and state agencies that enforce fair housing laws. And you can, on both of their websites, there's information on how you can file a fair housing complaint against a landlord or any housing provider for discrimination. It's totally free. It's pretty easy to do. I've done them with clients. You don't have to have a lawyer to file the complaint. They're pretty easy the form's pretty easy. It's easy to understand. The most important thing to remember is that the complaint has to be filed within 1 year. Statute of limitations is 1 year, meaning they will not consider a complaint unless you file it within 1 year of when the discrimination happened. Court has a little bit of a longer statute of limitations. So the other way that someone could, the other option is to file a complaint in state or federal court. That has a 2-year statute of limitations. So someone filing a fair housing complaint in court can do it within 2 years of when the discrimination happened. One of the downsides to court, I mentioned the other forms were free. Usually there's costs involved in court, filing fees, unless they're waived by the court, costs to serve the other side. But there's sometimes there's benefits and downsides to both options. So, I kind of ran out of time for this, but we have at Prairie State, one of the ways that we investigate housing discrimination is through our testing program. So if a client comes to us and believes that they're discriminated against, but maybe they don't have proof that they are, it's kind of like a secret shopper. It's kind of like a secret shopper thing where we have trained volunteers. They are not employees at Prairie State, but they do get paid a stipend for doing this work, that they go undercover to the landlord and pose as renters and see how they're treated. So maybe if we think that a landlord isn't renting African Americans, we might send an African American tester and a white tester in close time, maybe in the same day or within a day of each other, to that landlord and they both pretend like they're interested in renting, and then they see how they're treated and what they're told, and they write a whole report about what they were told and what they were showed and information that they were given. And if we find discrimination, we might be able to use that in a case against that landlord, and those testers could become witnesses for us. So kind of like I said, kind of like being a secret shopper. You're not there to necessarily uncover discrimination. You're just there to gather information for us about how you're being treated. You and here's some restrictions under the funding that we get from HUD to do this. You have to have a state ID, authorization to work in the United States, access to transportation, access to a computer. You cannot have an active real estate license or be a housing provider of any kind, actually, to be, so a landlord can't be a tester too. But if you are interested in being a tester for us, like I said, it's technically considered a volunteer position, but we do actually pay for it. We do actually pay per test. So if you even just complete the training, which is a 2-hour training, and then you do a practice test where you go and you pretend like you do a test, a practice one that the test coordinator who works for us will tell you to do and go through everything with you. You get paid for that. And then you get paid mileage. If you're driving somewhere, you get paid like the federal mileage rate. Tests kind of vary in price depending on how much, on what you're doing, but it's usually about $100 a test. So if you are interested in that, you are welcome to email us. That's the email address for interest in our testing program. Even if you don't know if you are and you want to just chat with us and find out more about it or get an application, it's fairhousing@pslegal.org, and you can send that with your you can send an email and either, ask for someone to give you a call or just ask for an application. And this is our contact information. So if you are interested if you need legal help, you can call. If you have questions about a fair housing issue, you can call us at 855-FHP-PSLS. Also 855-347-7757. That's the phone number. You can also call like the general Prairie State phone number as well, in Lake County, which I think if you Google it, it'll come up. It's 84, but this one works just as fine as well. Or you can go to our website that has all of our contact information as well, pslegal.org. And if you want to specifically learn more about fair housing, you go to pslegal.org/fair housing, and you can download a lot of our flyers and other information. There's a lot of really good information on there as well.